In this lecture, we shall discuss the appointment, qualification of magistrates, as well as the composition of the district courts. And we shall have this discussion under the context of Ghana legal systems and methods. Composition of the district courts. What is the procedure for appointing magistrates of the district courts? And what is the qualification for the magistrates who preside over the district courts? Now, the first point to note is that under Article 126 of the Constitution, the district courts has not been mentioned. But what we have under Article 126 is that the judiciary shall consist of the superior courts of judicature, comprising the Supreme Court, Court of Appeal, High Courts, and regional tribunals, and such lower courts or tribunals as Parliament may by law establish. In other words, apart from the superior courts of judicature that are established under Article 126, Clause 1, 126, Clause 1b indicates that there can be such lower courts or tribunals as Parliament may by law establish. Now, the district court is one of such lower courts or tribunals that the Parliament has passed a law to establish. And that law is the Courts Act of 1993, Act 459. So, Section 39 indicates that pursuant to paragraph B of Clause 1 of Article 126 of the Constitution, the following are by this act established as lower courts: A, circuit courts; B, district courts. And there's a C and there's a D. But my particular emphasis over here is that we are now clear that under Section 39 of the Courts Act of 1993 as 459, the district courts form a part of the lower courts that have been established by the Courts Act, the district courts. So Section 39 of the Courts Act 1993 as 459 establishes the district court as a lower court. It also establishes the juvenile courts as lower courts. So pay particular attention to Section 39 of the Courts Act of 1993 as 459 that establishes the district courts as lower courts. Then Section 45 is also very instructive. Section 45 reads as follows, and I quote, subsection 1. There shall be in each district the district courts that the Chief Justice may determine. Subsection 2. There shall be assigned to each district a magistrate who shall be appointed subject to the approval of the President by the Chief Justice on the advice of the Judicial Council. What is the import of this subsection 2? It tells us who appoints the magistrates. And it tells us who is going to approve of that appointment. It tells us that the appointment of the magistrates, that is the person who presides in the district court, the appointment of the magistrates is done by the Chief Justice acting on the advice of the Judicial Council and subject to the approval of the President. So whenever you want to deal with the appointment of the Chief Justice, remember there are 3 persons you must always mention. You must mention the Judicial Council, you must mention the Chief Justice, and you must mention the President of Ghana. Because the advice comes from the Judicial Council. Then appointment is done by the Chief Justice, and the approval is done by the President. So the first stage is that we will have the advice from the Judicial Council. After the advice from the Judicial Council, the Chief Justice may then appoint. After appointing, then the president of Ghana has to then approve of the appointment. Then the person can become a magistrate. So as far as the appointment of the magistrate is concerned, remember section 45 of the Courts Act of 1993 as 459. That indicates that appointment is going to be done by the Chief Justice, acting on the advice of the Judicial Council and subject to the approval of the President. Let's move on to section 45, subsection 3. It says that the Chief Justice shall specify the area of jurisdiction of the district courts. So when it comes to the area of jurisdiction of the district courts, we are told that the Chief Justice shall specify the area of jurisdiction of the district courts. So if the Chief Justice specifies your area of jurisdiction is Teshin, this particular district, you can't go as a district court judge and be hearing cases at Tamale or Navungu because that place does not extend to the area of your jurisdiction. Now, who are the categories of persons who are qualified to be appointed as magistrates? Who are the kind of persons who are qualified to be appointed as magistrates? So, if you look at section 46 of the Courts Act of 1993, Act 459, that is where you have the answer to. It reads as follows, and I quote, a person does not qualify to be appointed a magistrate of a district court unless that person is of high moral character and proven integrity and is a lawyer of not less than 3 years standing. A person shall not qualify to be appointed as a magistrate of a district court unless that person is of high moral character and of proven integrity and is of a lawyer of not less than 3 years standing. Lawyer of not less than 3 years standing, and then you will be qualified to be appointed as a magistrate. So qualification for appointment of magistrates, section 46, subsection 1. A person does not qualify to be appointed as a magistrate of a district court unless that person is of high moral character and proven integrity and is a lawyer of not less than 3 years standing. Now, even though we are being told that the person who presides over a district court is a magistrate, I want you to take note that the Chief Justice, even though we ordinarily will see him sitting at the Supreme Court, or even any justice of the Superior Court of Judicature, or even a circuit court judge, any of these persons can be nominated by the Chief Justice to come and sit as a magistrate of a district court. In other words, Chief Justice or even a Supreme Court Justice can be nominated by the Chief Justice to come and sit as a district court judge. And this is what you see from section 46, subsection 2 of the Courts Act. It reads as follows, and I quote, the Chief Justice, a justice of the Superior Court of Judicature, or a circuit court judge nominated by the Chief Justice may sit as a magistrate of a district court. So even though we have been told that the qualification for a magistrate is a person of no less than 3 years standing as a lawyer, and ordinarily somebody who is about 5 years can be appointed to serve as a magistrate, remember that even when that magistrate has been appointed, depending on the circumstances, the Chief Justice has the power to nominate a justice of the Supreme Court, a justice of the Court of Appeal, a justice of the High Court, or even the Chief Justice himself, or a circuit court judge to come and sit as a magistrate of a district court. That is the import of section 46, subsection 2 of the Courts Act. And then subsection 3 says that the sittings of a district court shall be held at the places and times directed by the Chief Justice. So this is actually the brief insight as far as the appointment, qualification, and composition of the district court is concerned. As far as the appointment is concerned, we know that appointment is done by the Chief Justice, who may be acting on the advice of the Judicial Council And after that has been done, we have to gain the approval of the president. That is as far as the appointment is concerned. We know the kind of people who are qualified to be appointed. They are people who have high moral character, of proven integrity, and are not less than 3 years standing as lawyers. As far as the composition is concerned, we know that it is composed of a magistrate. Magistrate, single magistrate will sit over there. But even though the magistrate may sit there in the district court, remember we have indicated that the Chief Justice, a justice of the Superior Court, or a circuit court judge nominated by the Chief Justice may sit as a magistrate of a district court. This is where we shall draw the curtains on our discussion on the appointment, qualification, and composition of the district courts of Ghana. Thank you.